and Antony, Nygate, and Shane Crooks and
Yes, Mr. Warner.
My lord and ladies, I represent Decolace Properties, the appellant on this case. My learned friend, Mr. McGee, represents the respondents being the joint liquidators of another company, which is part of the same group of companies, at least loosely defined, as Decolace's. This dispute, which this goes back to, concerns the true beneficial ownership of 11 properties, most of them in the care home sector in the area of Southend-on-Sea. Their value and associated goodwill, at least 7 years ago, which was when the key transactions in dispute took place, was assessed at about £17 million.
Just interrupting you for one moment, Mr. Warman, just for your benefit, for both of your benefit. We've had the opportunity of reading extensively into the papers, so we're very familiar with the background, the arguments. We've of course read the skeleton arguments and the judgment, and I know that each of us have dipped into the authorities also. So if that's of any assistance,
yes. So perhaps I'll skip over the background and go straight into how.
Well, do take it in your own way, but we are very familiar with the background.
Yeah. Very well. The witness statement, which was barred,
Yes.
is of course in the skeleton argument. The reason for its lateness was explained in the witness statement of Mr. Stravonides. I should just explain about him. I mean, the reason why he has had such a prominent role, if that's not clear from the papers, although he does say that in his in that latter witness statement, is that he is the director of the company which is the managing agent of Decolace, and he was best placed to know its affairs. That company itself is part of the same group of companies. I should add that since the events under focus, he has become a director of Decolace anyway.
Thank you.
The other point that perhaps isn't entirely clear from the papers is that from November to April, Decolace was acting as a litigant in person, although it was represented by me on direct access, crucially at the January hearing when the directions order was made. And he then explains, as in his witness statement, what happened and why he went to a fairly large firm of solicitors. And he says in that, so I won't go back over this, but I'm just summarising this brief point now, or making anything more of it. But that he says that they did not suggest it would take anything like the 2 months that it did take from April the 10th till June the 10th to actually complete the process, and the time cost to Decolace was far more than estimated. As a result, a crucial importance of the 3rd of July deadline approach, the litigation partner handling the case, Lorraine Lancaster, formed the view that the hearing was not a trial. And that was despite a belated suggestion from Simmons, the solicitors for the respondents, to the contrary. But as a result of that, at least one can infer, she did not truncate either the statement or the vetting process on the basis that to avoid the evidence being barred, they had to go on June the 3rd with whatever they had at that stage. Instead, she continued the vetting process and completion process for another 7 days. Now, the judge's decision, which we're appealing, is based first of all on CPR 3210, which I'm assuming the court is familiar with. In addition, the judgment, or certainly the respondent's defence of it on this appeal, contains 2 further justifications, and I'll just set those out. The first one, of course, as I've already indicated, is was this really a trial? The second was Judge Moyedin right to hold that even if it was not a trial, the lateness of the witness statement meant that there was an implied sanction, which required Decolace to apply for retrospective time. And then the third is, and this seems to emerge primarily from the respondents' skeleton argument, although it's based on to some extent an interpretation of the judgment, that in fact the judge was able to bar the witness statement, crucially the supporting, or bar also the supporting documentation by applying the overriding objective. I should say that conveniently also, although it's effectively a double-edged sword, because that also allows us, or means it fits in with our ground 2 of appeal, which we say the judge should also apply the overriding objective, albeit in the opposite direction on a different assumption of what he's decided about the But I deal first with grounds 1 and 4. Which summarise our challenges to the judge's decision. In summary, we say it's common ground that the application was not bound to be determined at a trial until the hearing of January 2025, before Judge Ashley, which was in fact then converted into a case management conference. Secondly, the indications in the substantive provisions of the directions order are mixed, but in our submission the balance is against there being a trial based on that alone. But thirdly, the court itself failed to classify the forthcoming hearing as a trial, and in its communications with a party or parties failed to state either explicitly or by necessary implication that it was a trial, and in fact, in our submission, stated necessarily implying the opposite. And the final issue, which is a separate ground 4, is whether the issue is whether the hearing would create finality and a res judicata or stoppel, and whether that, according to one high court authority, is one of the hallmarks of a trial. So perhaps I just go through and to some extent elaborate, but I perhaps if the court is happy to do so, feel free to interrupt if I'm going over points that you've already fully grasped, because I was just going to take you through the primary points in an argument on.
Of course, you must take it in your own course. So do you want us to turn up your skeleton argument?
Yes, it's from I'm going to deal with ground 1 first.
Yes, certainly.
It's page 6 in the bundle, in the core bundle. The first paragraph actually just explains, to the extent necessary, is one of the key issues was, and perhaps the key issue was whether the transfer of the properties, whether the reported transfer of the properties in 2020 to Decolace was in fact genuine, or was it, or i.e. alternatively fabrication, or even if it was, whether it was a sham in the sense that neither party really believed in it.
And would you accept that that is the kind of issue which one might normally expect a trial to resolve?
If in other circumstances, if it was this was going to deal with a res judicata point, but if in fact it was going to be a decision in rem, and that all the parties who would be affected by it to establish the true ownership of the property, which is the ultimate point, because the whole point about the dispute about the transactions in 2020 or 2019, 2020, I should say, is whether they were effective to transfer ownership to Decolace or not. And clearly, if it was a sham, or if the documents were even worse fabrication, then they clearly wouldn't be effective to transfer ownership. So it is so the ultimate question is, And the only question which Decolace was focused on in its application was whether the Land Registry should go ahead and register its ownership of the property on the basis that it was the beneficial owner of the property. Well, I say the properties, I'm talking about their own properties.
But as you point out in your skeleton, your client hadn't been involved in the trial, which had by that time happened.
Yes, exactly.
So resolving of this issue, given that everything else had already been resolved at the trial, was pretty final, wasn't it? This was the only outstanding issue by then. So there'd been a trial of everything else.
But the application was made after the trial had taken place, but before judgment had been handed down in the trial, and there was a gap of 6 months before judgment was handed down. When the judgment was handed down, which was in April of 2025, in other words, before the final hearing on trial.
Yes.
Then that did, but it was then subject to an appeal. The point is that the primary point is that it still didn't establish all the parties who could have claimed, because there were also on the basis of the evidence that the Decolace submitted, and indeed. I think it was in the original trial bundle, but I'm not sure about that because I wasn't involved in the original trial. There was a mortgagee on those properties, which had entered a mortgage with Decolace in order to allow Decolace to buy the properties. And that mortgagee was entitled to be joined as a party, and as it wasn't, and no attempt was made to do so, that mortgagee could still now make an application for 40.5. CPR 40.5 to set aside the order. So it certainly wasn't at the time when the application was made, and even when the trial took place, if it was a trial, or was due to take place, that possibility was still open. Still there. So in that sense, it wasn't a final decision.
Just before you develop that submission, can you just help me at this point about the mortgagee? Because I confess that comes as news to me, and that may well be my fault. I thought I'd read the papers with tolerable thoroughness, and it may be that point is in the papers and I have missed it, in which case I apologise. But can you just help me? Where does that information come from?
Well, if I can do it backwards, I should explain that this was a point which is argued in the skeleton argument, but my learned friend responds to the point that I've made in the skeleton argument on the basis, if I can find it. He says that the point is that the trust, which is the mortgagee, was in fact wasn't a separate legal entity, which I don't think is in dispute.
I'm sorry, we're at cross purposes. My question is not about legal consequences. My question is about the factual substratum. So could you direct me to the evidence which tells us about the existence of this mortgagee?
Yes, my point was just to say that issue is not in dispute between the parties, but I should take to the evidence anyway. If I can take you to the core bundle page, tab 15, page 148.
This is Mr. Ashworth's order.
Yes, this is Mr. Ashworth's order, which I thought was a good study because he had access to all the documentation. including documentation to do with the actual transfer itself. You'll see there under G, it refers to the Harvest Trust, to its shareholder Harvest Trust. It's the Harvest Trust which has the mortgage.
Well,
Now the
yes,
underlying.
I'm sorry, Mr. Waldman. All we know from this document
Hmm.
is that there is a reference to an entity described as the Harvest Trust, who is said to be shareholder in the first defendant. There is no mention in this document of any mortgage.
No, that's absolutely correct. That's absolutely correct.
So I repeat my question. Please could you direct us to the evidence which discloses the existence of the mortgage?
Can I just, well, to do that, I would have to have in front of me the original bundle that was in front of Judge Ashworth and indeed in front of Judge Moydin.
Can we
And I'm not
perhaps
sure
rewind?
that it is. It
Can
may be in here somewhere. I'm not sure that it is. But
Mr.
it
Waldman,
wasn't matter.
can I just interrupt? Let's just rewind on this. So perhaps you could, you said there's no dispute about it as between both of you, that there is such mortgage. So perhaps you could just tell us, so far as you are aware and you're both agreed, what the mortgage is, the circumstances in which it came about, and what the relevance is to the issues that we have to determine. I think that would be helpful to us.
I need to clarify that a bit more. There is a dispute about whether this creates a res judicata and whether, which is binding on the mortgagee. I think that's the point that my learned friend was making. So that's a separate issue, which I was going to deal with. But I can take you to some documents which I think assist Lord Justice Arnold on this matter, because in the supplementary bundle there is something. Because it was, just to be clear, the witness statement of Mr. Stravinidis,
Yes.
which was not accepted,
No, understood. No.
has, by the judge, has both references to the mortgage, I believe, which is, and the full statement is in the bundle, but also it has a list of documents, which
Yes.
perhaps is more decisive. And the document itself is not here.
I think we've got
And
the
the
witness.
reason it's not here, I mean, just to explain,
Don't worry about the mortgage itself not being here. That's not
Oh,
important.
right, okay.
If it's referred to in the witness statement, that will tell me all I need to know for present purposes. It's just that, as I say, this is not something I'd picked up before, and as I say, it may well be my fault, and I apologise.
yes.
But
No, your lordship is absolutely correct. It isn't made clear. Perhaps because neither side thought perhaps it has the significance that the court thinks it does.
I'm just looking at the list, the schedule of documents,
Is it page 94?
and
External page 94.
so it's not the legal mortgage and assignment of mortgage of the 21st and 31st of March 2020 then that you're referring to.
Yes, I am. Yes.
Well, there we
I
are,
think it might
page
be in two
91,
places.
there it is.
I think it might be in two places. Yeah.
Numbers 12 and 13 on your list of documents. Well, not your list, the list that was attached to the
Yes.
disputed witness statement.
okay, all right. All right, that's helpful. Thank you.
Now, I was going to, what is said about this, as I understand by implication, by my learned friend, Mr. McGee. Sorry, I haven't actually found the reference to it, but he does mention it in his discussing argument. Is that he says, although I don't think there's any evidence he uses for it, that one of the defendants who was at the original trial would therefore, he says, be bound by the decision made in the freezing orders, when the freezing orders were granted, and the order against the Land Registry. It is Mr. Maria Christoforou, who is one of the defendants. And he says that these trusts, which we also accept as common ground, these trusts don't have a separate legal personality. and therefore they have to be represented by trustees. And she is, I should perhaps, I'm putting it into my words because Mr. McGee has left this point implicit, but you know, he'll correct me if I'm not misstating his case. But he is saying that the position is that a trustee is bound by the decision, even if she was being sued in a different capacity. And the rule on that, which I think emerges from Spencer Bauer, I'm relying on Spencer Bauer, which becomes quite complicated. But this is the more minor legal point, is that if she was a beneficiary of the trust, then as trustee she would be bound by a decision made against her personally. But if she wasn't a beneficiary, she wouldn't be. In fact, I'm going to have to give this on instructions, but what I can say, but that's not least because both sides are relying on instructions or influences about this matter. So the position is as follows, that which is again in the papers, again is in the papers and is summarised in this list, which I'll take you to in a minute. But the position is that Miss Cristoforo actually resigned as a trustee back on the 4th of January 2024. And her position was taken by another trustee who isn't a defendant. I should say that he's actually her son, but he's not a defendant in these proceedings. She, I should say, is an elderly woman. I think that's common between us. However, what's also true is that in December 2022, and again, this is the bit which I say is also apparent in the list of documents, but this is a point against me in one sense. The mortgage was retransferred from the Harvest Trust to another trust within the group called the Petra Trust, and in favour of Mr. McGee, we readily accept that when Mrs. Cristoforo ceased to be a trustee of the sorry, let me just get this right, of the Harvest Trust, she became a trustee of the Petra Trust, i.e. the new trust. However, it is also the position that there were two other trustees of the Petra Trust, so there were three trustees altogether, and therefore she's in a minority.
But Mr. Woolman, this I can see would go to the issues that the judge was going to have to decide at the hearing stroke trial, whatever we decide it was. I'm not sure how this helps us so far as your grounds of appeal are concerned, and the refusal of the judge to permit the admission of the witness statement, which deals with all these matters. And the content of the statement, I don't think is going to be helpful for us in deciding your grounds of appeal. Although I perfectly understand you are obviously immersed in the detail.
I'm grateful.
Had you been running the hearing for those 3 days, but I think you're slightly going off track on what we need to understand, and you need to address to help us as to, was this a trial? Was it Denton? Should the judge have allowed the witness statement and documents to be filed?
So perhaps I can go back to the question put to me by Lord Justice Arnold, and my answer to my attempt to answer it. I mean, maybe.
By all means, yes, thank you.
And the point put in particular by him, but more generally by the panel, was that if this all the parties, if all the parties were before the court, embraced by these proceedings, then the decision would be a final decision, binding on all the parties, and that would be the end of it.
You say that's not the case.
And I say that's not the case, and that's and that's for several reasons, of which the first one I just got into rather deep water, which perhaps I can now extract myself from. But that's the first point. That not
I think
all
I
parties-
threw you a rubber ring.
The second point, though, is that the freezing orders were expressed as being interim orders. I mean, there isn't any dispute about it. They say until further order. And the order against the Land Registry was expressed as being to protect those freezing orders. And clearly they have a role in fortifying the defences. Our case is that and I think this remains our position, of course, the freezing orders would have some utility, even without that defence or protection. But nevertheless, they're expressed as having protection. Clearly, they do add a further layer of protection because against the HM Land Registry, because if for some reason there's been a mistake, say just a technical mistake in any freezing orders, then the parties would still be unable to progress. Decolace would still be unable to progress its registration if the injunction against the Land Registry applied as well. So, but the point is that they were interim orders. They could still be revised, and certainly they could still be revised at the time that the application was made. And I suppose with the passage of time, it becomes more and more clear what the position is and what degree of finality there is. But in principle, if it came to light, for example, that inadequate, and this is pure, this isn't a suggestion, this is what happened, but I'm just mentioning it because it's an interim order. If, for example, it became clear that improper, the applicants for those freezing orders and that injunction, which was done without notice in the first place, has not given proper disclosure, have misled the court, in other words, or at least
Lack of candour.
wasn't candid. Then, in principle, those orders could be set aside, and that remains the position. Notwithstanding that since then there has indeed been a judgment handed down. The third point is that the fact that this is open is that the matter is still at large because it's an interim order is also evidenced by the stance taken by the respondents to this appeal, who have also sought to reserve their position, who have sought to explicitly reserve their position, I understand, unsuccessfully when they tried to get the court to accept it. That doesn't mean that they can't bring an action, but they wanted to reserve their position to bring a further claim under the Insolvency Act, Section 423, to set aside the judgment. And that was a hearing that was just, and I didn't attend it because it was actually not brought against Decolace, but brought against one of the other companies. But that was a judgment which was only decided less than 2 weeks ago. So the stance taken by the respondents is still that the matter has not been settled, because otherwise they wouldn't have applied for that. And that view is, in our submission, well-founded for the reasons I've just explained. So, in summary, that point in itself, I don't think Lord Justice Arnold was suggesting that it was decisive, but he rightly said that surely it's an important fact. pointing towards a trial, that this would have been potentially a final decision and resolve the matter. And that's why I drew the distinction between in personam and in rem.
I was a little bit puzzled by that. Can you explain to me what you meant by that?
Yes. Well, I suppose by in rem means that the ownership of the property is established for that nobody can challenge it. Right? It's against the whole world.
But
That's all.
I'm struggling to understand the concept of a judgment in rem. We're not talking about an admiralty action to seize a ship here, which is, I believe, and I stand to be corrected, the only action in rem known to English law. Otherwise, actions are always in personam.
I wasn't making that final legal distinction. I fully appreciate, and without knowing much about it, what your lordship says. But all I'm saying is that if to the extent that in rem means no, it doesn't, leaving aside the procedural consequences within an English law. If in rem just meant to mean that it establishes the right to the property, land, against the whole world or anybody who was obviously there may be somebody who we knew nothing about who may turn up. I mean, it could be through adverse possession, even, I suppose, and claims right. Then obviously no order is going to withstand that kind of challenge purely on the basis of res judicata. Of course, it may be complete nonsense, but in principle it can't. But that's not what I'm saying. I'm saying it in a more limited sense in terms of the parties who were identifiable and identifiable by, and would have been identifiable by the judge, Judge Boyding at the hearing a year ago.
I'm sorry, I'm not following this. I'm sure it's my fault. To my thinking at the moment, and please correct me if I'm wrong, one needs to distinguish between a number of different concepts. Firstly, an action in rem and an action in personam. Secondly, the effect of an order, because even in an in personam action, an order may be expressed to be effective more widely. So we see this, for example, in the context of privacy cases. Then you have the separate question as to res judicata, as to which the normal proposition is that a judgment is binding only on parties and their privies. But those are three different questions. And at the moment, I'm struggling to understand the point you're making about in rem, because any judgment is only binding, as I say, on the parties to the proceedings and their privies. So how is the judgment that would result from the application in this case any different?
Because I suppose perhaps it was wrong of me and misleading of me to use the in rem and personam distinction in the very precise way that you defined it anyway, and perhaps more generally. What I meant is within the circle of plausible candidates, people who might have a claim to have interests in this property, not all that circle were before the court and therefore not bound. So I'm talking about as a pragmatic matter of can this really be considered as a pragmatic matter? Would it be being considered as a pragmatic matter of final judgment?
All right, can I just try and understand that submission a little more? So I understand your starting point. You say is there are potential candidates to interests in these properties who are not before the court. Let's assume that's factually correct. And it may turn out that it's not in dispute. But what legal consequence do you say is flowing from that fact if there is a determination as between those candidates who are before the court?
Simply this, that if it was, your point was that was an important indicator that this was going to be a trial. But my point was that given the extra seriousness of the trial, If that was so, and a normal set of proceedings of steps were taken leading to that trial, then it may well be that those other parties would have been joined. But that
Right,
didn't
so
happen.
the point you're making is that if this had been a trial, you would have expected all relevant parties to be joined, and that has not been done.
Exactly.
Okay, that point I understand, thank you.
So that is, in my submission, that's not a clear-cut indicator that this is intended to be a trial. And one needs to put it anyway in the context of the other indicators. But I'm grateful, Your Lordship, for pressing me on that point, because it didn't, and extra thought, which I don't think I've given. If I may go back now to my skeleton argument.
Well, we get your submissions on ground one start at paragraph 12,
Yes,
and we
I took you through some of the case law on 14. I don't know if I need to go through that with you now.
that's a matter entirely for you.
Fortalix and Benny is we say is just neutral, which is what the judge said. So we don't have any argument that it neither helps nor hinders either side. But it's also common ground that, of course, there's no definition in the CPR of a trial. There's no proper definition subject to the case of Tickle, which I was going to come to, and I will come to separately.
Yep.
As to what it means. So in ordinary language, what does a trial mean? And at paragraph 15, I've suggested some of the words, which is actually is, and perhaps I should have done better, but I mean, if we look through the dictionaries, that is what seems to be the common element, and that's most of the dictionary definitions. In this context, obviously, a trial, I mean, lots of other
Well,
things.
if we take your definition in paragraph 15, trial is a judicial examination and determination of the issues in a dispute by a competent tribunal in accordance with the law, then the hearing that was directed in the instant case would seem to fit precisely that definition, would it not?
Absolutely. No, I accept, and well, you'll see that in paragraph 15, I accept that. But the point is, it would apply equally to a final hearing of an application as well. And clearly there is a distinction because the CPR recognises there's a distinction between the two. So how, the question is, how do you distinguish between the two? What I'm saying is that the ordinary language doesn't help us to distinguish between those two different events. Now, so
That's helpful, and I'm grateful for that clarification. So could you crystallise for us what you say the distinction is?
the distinction in, well, you mean in terms of the implications of the distinction?
No, the distinction between a trial and the final hearing of an application, because what you're saying is you accept that what happened was directed in the present case would fall within the definition of a trial, but you say it's equally could be categorised as final hearing of an application. So the question is, well, how do we distinguish between a trial on the one hand and final hearing of an application on the other hand? Now, is it simply, as it were, a multifactorial assessment, or is there some definitional criteria that you are able to offer us? I mean, at the moment, I'm understanding that you can't offer any crisp definitional criterion, but if you have one to propose, I'd be interested to hear it.
My lord, I don't as such. I think it is multifactorial. What my submission is the decisive point in our submission is the following: that if the factors are ambiguous, either factors on both sides pointing in different directions as to whether it's a final hearing or a trial, then the judge who himself is giving the directions leading to the trial I say the judge, the court, in fact, and I'll come to that important distinction. The court must state unequivocally whether or not it's a trial. And that's really as a matter of practice, because otherwise this sort of confusion is bound to arise.
So is that a submission that the court is required to direct a trial, and if it doesn't direct a trial, then anything else is not a trial?
No, the court should say one way or the other. I'm not saying that. If the court fails to do that, then, which is the problem that we're grappling with today, then one has to go back to all these other tests.
Right.
But I'm saying, ideally, the court would be expected to do it. And my submission on that is the following: that the judge, this is Judge Ashworth, in his directions did refer to a final hearing. He didn't use the words, he didn't refer to any trial. And perhaps of equal, if not greater importance in some ways, the court itself, and I'm going to be submitting that a distinction should not be drawn between the court, i.e. the judge, and the court, i.e. the court officers to whom certain tasks of an administrative nature have been delegated. But those two things, which my learned friend has tried to draw a sharp distinction between, should not stand. The court is the court. And I was going to go through that in a little more detail shortly. But the court, clearly the judge and any officials who are acting under delegated authority on this matter should be consistent. That goes without saying. But what one would expect as a matter of good practice, if there is any ambiguity, for that matter to be clarified by one or the other or both. And because without this determination, I've mentioned the issue of fees, which I'll come to in a minute, that is clearly very dependent, or entirely dependent on whether or not it's a trial. But it's not, there are other matters as well, although and I haven't put those in my table because they're not mandatory. I'm thinking in particular of the pre-trial checklist and the pre-trial reviews. I mean, the court has the power to dispense with those, and I suppose my learned friend would say, well, we didn't get any. There was no checklist, there was no pre-trial review. But he would say, well, I suppose that just means the court decided not to do it. But in my submission, well, we don't have any evidence on the court. I suppose in theory we could get it, but in my submission, that the inference to be drawn from the failure to serve a fee notice, a trial fee notice on parties, is probably the same approach was taken to the pre-trial checklist, that it was never considered because it was considered not to be a trial. And that's the natural inference in my submission that would be drawn. But all these factors all mean that there was both internal and external reasons why the issue needs to be clarified. When I say internal reasons, to the extent those internal reasons are then reflected in outbound communications between the court and the parties, then it becomes not just an internal matter, it becomes an external matter as well. Because at the end of the day, the litigants themselves need to know whether this is a trial or not.
Certainly it's an object lesson of this case. The courts need to be clear about what they're doing. So that point is well made.
But if you're asking me, do I have a helpful suggestion how the CPR itself could draft a trial? Well, based on the existing practices, I don't think I could have. I mean, obviously it could be simplified by saying these are the key things, but that would be a distortion of perhaps how judges would feel.
Yeah, well, we're not the rules committee here. So no doubt the rules committee would be grateful for any assistance, but that's for another day.
So
So what you've given us is your hallmarks of the trial at 17, and then we see those in your table.
Yes, and I've gone through to some extent in the comments on. Would you like me to go through shall I go through the individual comments, perhaps on at least on the more important ones, and the ones that are actually seriously contested in the Stilton arguments by Leonard Friend. First of all, on the points of claim, there was a direction that it should be points of claim and defence. My learned friend suggests that is he seems to be saying that's quite a strong point. He does, however, and he has adduced, to be fair, very fair to him, he has adduced authority to suggest that there has been challenge of whether points of claim can really be considered statements of case. That in fact the decision is that they're not statements of case, and therefore they don't have the same weight. And that's one reason why I say it's weak. But the real reason that I put that it's weak is that points, just on the normal language and the normal way it's interpreted, particulars of claim means particulars, i.e. you go into details. Admittedly, the CPR says those details should still be concise, but nevertheless, particulars does mean details, whereas points is meant to be something much more succinct. I accept that in practice sometimes it isn't, but then in practice also particulars of claim are often not are far more detailed and lengthy than they should be. But that's the key. So in my submission, that is a point against us, but it's only a weak point. I should add, apart from that, maybe although the matter he didn't consider it in any detail. It wasn't argued before the judge below in any detail, and indeed he didn't refer to it at all in his decision. Maybe he considered that was an area he didn't want to get into. So he has not made any comment on that point. The next one, which is a matter of some degree of contention, is the compliance with Practice Direction 57AC. Now, perhaps I should take you to. Sorry, maybe I didn't. Do you have the directions order in front of you? Because that's probably. But it says it's the
Page.
Page 146, or it's on the tab 15. I have to go to various bits.
Thank you. Yep.
Yeah, so paragraph 10 on page 148.
And that one, yes, thank you. Now, I've seen this sort of argument in various forms often being waged in court between advocates on either side. If you refer to something explicitly, does that mean acceptance that you had to put it in because otherwise the opposite would have applied, or is it just confirmation that what that would be is the default position anyway? My learned friend says, of course, that shows it's meant to be a trial because Practice Direction 57AC is to be used at a trial. But of course, there's nothing to stop it being used in other suitable cases, and this is clearly a suitable case in view of the degree of contention between the parties and the degree to which, in particular, the respondents were asking for disclosure of all kinds of documents and making all kinds of suggestions about the. In summary, they were suggesting the original agreements were a sham. So it's that's why it needed to be. But that in itself doesn't suggest it. In fact, in my submission, if it was just confirming what the position would have been anyway, if it was a trial, if that was what it was done, it would have said something like the parties are reminded of CPR Practice Direction 57AC, or the party's attention is drawn to that.
Would that be in an order, or wouldn't that be more likely to be a recital?
I suppose if you adopting a fairly purist view, but in my experience, I often see those kind of comments put in, and indeed in the model directions for trial. Those are the sort of comments that are often put in the model directions for trial, which in fact were not used in this case, which we say is another indicator for what it's worth that this was not meant to be a trial. But that's what one would have expected. So this does lead to it's led to a sort of secondary point made, and that's whether what the status was under that provision of the 4 witness statements, fairly short witness statements, but 4 witness statements which accompanied the original application made back in December 2024, because they were just done as witness statements to support the application, and they weren't, and there's no question that them being done under PD 57AC. This is referring to forward-looking. In my submission, this is referring to forward-looking witness statements. There's no suggestion that the ones that have already been submitted had to be reworked. I'm not. This isn't. When I'm focusing on those, I'm not making any point about their importance. They're not very important. 90% of Decolace's case, at least 90%, is in the evidence which was not allowed. But it does cover a few peripheral issues. Those.
I'm sorry, I'm sure it's my fault, but I'm struggling to understand the point you're making about the 4 witness statements. Is it your submission that the existence of those 4 witness statements that came in at the time of the application is a factor pointing against a trial, or in favour of a trial, or neutral?
I'm suggesting that I don't understand. My learned friend is suggesting it's in favour. It's an indication in favour of the trial. I'm suggesting it isn't. I'm not sure I need to go any further than that.
So you would say that's neutral?
I'm saying that that's neutral. Yeah.
Okay.
Yeah.
In your table, it's on under trial week.
Oh, the overall 57 AC is under trial week.
Yeah, but there's 2 different points here.
Yes.
The one point is the provision in paragraph 10, which, as you rightly say, is forward-looking and requires compliance with PD 57AC. And in your table, that's the point you accept is pointed towards trial. You say it's weak. But then you've raised a different question, which is, well, what about the witness statements that had already been served in support of the application? And as I understand it, your position on that is that the existence of those statements is entirely neutral.
And it's entirely neutral, not least because it's not clear from this order whether or not they could be admitted to the final hearing trial.
Well, I think Mr. McGee's position on that is that it's implicit, if not explicit, that they couldn't be relied on.
And therefore, but the point is, which he's entitled to say what he wants, but which he's got, you know, as far as it goes is fine. But he then goes on to make a further point to say that is further evidence that this is a trial. That's what he's saying, and I'm saying it doesn't suggest that at all. It's not even clear, and therefore I am to some extent also challenging the premise on which he makes that point.
Okay.
But perhaps I think this to some extent is a secondary point, and I perhaps should suggest perhaps with your permission we move on to the next.
Yes, please do.
The next point, if we can go back to my skeleton argument again, the next point in the table well, the length of the hearing, 3 days, I say is neutral, because the judge accepted it, so that's not really an issue anymore.
You've skipped over D because you think you've bottomed that one out, do you?
Oh yes, sorry, because I don't. But as far as I recall, but anyway, if my learned friend has something.
As expressed in paragraph 11 of the order made by Lance Ashworth KC, it is not just final hearing, but final hearing for the determination of this application, which will, so a final hearing to determine the ownership or not of Decolace's claim to the 11 properties. What is the difference between a trial and a final determination of Decolace's right to ownership of 11 properties?
Well, it's clearly the determination of the application is what the application is seeking. And what
Yes, no, final determination. I'm suggesting.
no, it's
that
not saying final. It's saying the final hearing, which isn't the same thing.
Right.
No, but that was meant to be not a frivolous point. I was making a serious point that the final hearing is precisely the terminology used, particularly in the insolvency courts, when there's for determination of any application, which isn't a trial. That's the phrase used. And of course, it is the final hearing because there won't be any further hearing subject to an appeal. But
I think
that doesn't mean final determination in the sense of determination in any way that goes beyond the strict terms of the application. And the strict term of the application is in itself limited in the way that I suggested before.
The practical reality is that this will be a final determination of Decolace's right to ownership of these properties.
But only as against
Decolace.
it will determine Decolace's ownership only if for example it decides that Decolace does own properties. It would only be a final determination in favour of Decolace as against the liquidators in the company they represent and the other defendants in the case, and similarly vice versa. But that's really going back, if I may, unless I've misunderstand your ladyship, that's really going back to the point we were debating before. What I'm saying is, in response to your comments on paragraph 11, is that the term final hearing has become something like a term of art. That just means, because you have to have some term when you expect the last hearing to be. But I think you will find, although I haven't got it immediately to hand, there was even reference to the hearing before in the correspondence and so on, the hearing before Judge Ashworth, which became a CMC, that was considered to be or might be a final hearing. But it doesn't mean very much, that's what I'm saying.
All right, you were going on to disclosure. You dealt with length of hearing, so that was neutral. But I don't think
yes, I saw what I should have
sometimes
done.
applications can take 3 days, and heavy applications can take 3 days, even a week.
Or
I've sat
more
on
in
one.
my experience.
My experience a lot more.
In any event, the
So
judge thought
anyway.
it was neutral, so
Yes, I think the next 2 points, F and G, were not seriously contested. Obviously, F is a weak point which really limits point B, and taking the two together, they're therefore not really strongly determined one way or the other. Taking B and G and B and F together. No reference to Part 32. Well, that should be read alongside those standard directions for trial, because the standard directions for trial specifically spell out, and this is one example where I say attention is drawn to, they specifically spell out and repeat expressly the provisions in CPR 32.10. The judge didn't adopt the standard directions, and he didn't make any reference to 32.10. And the reason that the standard directions do that is because that's one of the most important elements of its being a trial, as opposed to a final hearing. At least in my submission, it is. It's difficult to see, if one looks through the standard directions, many other cases where they effectively reproduced in slightly different words, I admit, what the statutory provisions, which are CPR provisions, which are a consequence of it being a trial, or a consequence of anything else that those standard directions have made. So H is clearly a contentious one. Now, what's said about that is actually just in the paragraph that we've just been looking at, paragraph 11. Because after saying the final hearing for the determination of this application, which shall include the live evidence of witnesses, that's the limit of what it says. Shall include the live evidence of
I'm
witnesses.
just struggling to see how that means other than that there's going to be live evidence,
Yes, no, absolutely, I accept that.
including cross-examination.
Absolutely, no, I fully accept that. There's no dispute about that whatsoever.
Right, thank you.
But what my learned friend is saying, that it goes beyond, that's not consistent with it being a final hearing rather than a trial. And he's saying that sorry, perhaps I'm trying to pick up some of his points now because I appreciate that I may not have much
No, that's
time.
most helpful.
So perhaps I can, and of course I realise the danger in doing that is that I've not put his case properly. But yes, this is in his skeleton argument, at paragraph 43. That's on page 27 under tab 2. Now,
Yes, well, that's what that was the point I was seeking to draw to your attention,
right.
Mr. Wallman, is that it just reads to me as though it is mandatory. Shall the live evidence, which shall include the live evidence. It seems that doesn't seem to me to be permissive. That seems to me to be a direction. But you
well,
disagree.
First of all, because when it is in my submission, and you can see that from Picard, for example, the Picard case number 10, that when the court typically says that there will be cross-examination of all the witnesses, or perhaps as in Picard, there will be cross-examination of all the witnesses except for A or B.
So is your submission that absent a specific reference to cross-examination?
No, so that was, I'm just saying those were the words used in Picard. No, he could have used, I'm assuming the words live evidence and cross-examination are interchangeable.
Yeah, good. Okay.
So are you
So
saying there's a difference between shall and will?
No, I'm not saying that either. What I'm saying is that here it's the key word here is shall include.
Mm-hmm.
Shall include the live evidence of and the absence of the definite article of witnesses. It doesn't say of all the witnesses. It doesn't say, as in so many other orders, all witnesses shall attend is live evidence, or even that the relevant section of the CPR. And perhaps we should go to those sections because there's a few points I want to make about 32. So if I could take you to the, you've probably got your white book. We did.
Well, actually,
We're out of date.
My learned friend was
We've got
very good
them in the reports as well.
including the relevant parts in the authority handbook.
so what do you want us to turn up? Which order do you want us to turn up?
So I'd like you to go to, first of all, to 32.6, which is at page 31. And you'll see there, these are to do with evidence in proceedings other than the trial. It says the general rule is that evidence in hearings other than the trial is to be by witness statements unless the court requires otherwise. So that is clearly saying that the default position is no live evidence, but the court can direct otherwise. And this is laying down a clear marker that the court is going to direct otherwise. But it's not going as far as to say, in other words, it's leaving it to the discretion of the judge that every witness who comes will be required to give live evidence. He's leaving it open to the discretion of the judge. But he is putting everybody on notice that that's the default rule doesn't apply to 32.6.
Thank you.
And my as you will see from my Land Registry argument, he's saying, which in my submission isn't correct. It says if the claimants wish to challenge the written evidence of any witness, he's saying that this is just to say that my interpretation doesn't make sense. Because it means if the claimants wish to challenge the written evidence of any witness statement, then it was for the claimants to apply for and bear the burden of justifying cross-examination under CPR 32.7. But as you will have seen, that 32.6 means you don't need, if the court is so minded, you don't need to go to 32.7. And that's the purpose of it, to lay down exactly that marker. You don't need to apply for 32.6. You can just because the judge was going to have just to explain the mechanics. I mean, the judge, apart from anything else, was one clear day for reading, for the judge's reading, and in the course of that day, the judge would no doubt look at certain arguments from the papers, and he may well decide in the course of that day and sent a note to counsel on both sides, and he was in contact, as is normal, with counsel on both sides, to say, oh yeah, well look, you can let off, I'm not interested in hearing live evidence of witness A or witness B, but certainly witness C needs to come along and give live evidence, or something of that nature. In other words, it was really at the discretion of the judge on 32.6. And that's why I'm saying that's not in itself a good point. And what my learned friend needs to do is to say, well, why wasn't this expressed much more clearly? Because it is, because witnesses are not always easy to persuade to attend, and it's obviously, and it can be costly to get them to do so. So, if the judge's intention was the trial that all the witnesses had to come along, otherwise their evidence couldn't be admitted, their written evidence couldn't be admitted, then he could have said so in terms. But that's not what the direction said. The direction, I mean, this is perhaps the underlying point is, both on this and the point in which we looked at under the rest of that paragraph, and also the paragraph dealing with the practice direction 57 AC, is that the wording in all these cases is non-standard wording, not used in other orders.
Well, perhaps this just throws up the danger of not using the template.
Well, it may be just that, or it may be that the judge thought, this is quite an unusual case. I'm going to deal with
Why
it.
is
I'm
it
going
unusual?
to tailor-made the directions.
Sorry, why is this case unusual? I mean, there's obviously, as you know, the Chancery Division is not my patch, but financial remedy cases absolutely are, and we regularly have to have trials to decide where the beneficial interest in very valuable property and land belongs.
Yes.
But this is even from my not belonging to the Chancery Division, this doesn't seem much unusual about having to work out the beneficial interest.
Yes, well, no, I accept that, but that level of generalisation isn't. But there are specific features about this which are quite unusual. I mean, I can take you through them. But my real point is the judge, in my submission, the judge was tailor-making these directions to fit the requirements of the case, and he perhaps, I mean, quite one interpretation, he was silent on the question of whether that meant it was a trial or not, because he didn't consider that at the time of making the order.
Okay, thank you.
So if we can go back to my skeleton argument.
Now we have your point on the no mention of trial in the order.
I'm looking at the text. What I should be looking for is the table. Sorry.
And I think you've already indicated that you take issue with Mr. McGee's observation in his skeleton argument that the fee notice doesn't help, he says,
Yeah.
because that's an administrative back office thing and it's nothing to do with, doesn't cast any light on the directions or the issue
Sorry,
as to
just
whether it's a
going
trial.
Yeah, just going over to the fee notice point.
Yeah.
That's a K. Sorry, that's on the next page. I don't know if you.
Yes, we have it.
I wanted to make some fairly detailed submissions on that. The matter is dealt with to some extent by what Mr. Perhaps I can take you to what Mr. McGee says on this at paragraph 65 to 67.
Thank you.
That's on the core bundle page, tab 2, page 31. So he's making, as I see, 3 points here, which in my submission are each of which is wrong. First of all, he's saying that it was common ground that the application that the consequence of that if the hearing was a trial and this was a consequence of the directions that had been made.
Yep.
The common ground is that before the hearing, before the CMC, it is, as I understand, common ground, unless Mr. McGee agrees, that it was open. It wasn't clear whether that it would be or not, and indeed there was some assumption it would be a final hearing, not least from Mr. McGee's own skeleton argument at that hearing. So I don't think it's in dispute that before that hearing, it looked as though it may well be a final hearing, although that was not certain, but it turned out to be a CMC, and therefore it was then, it was the directions then that one that can only look from that point onwards to decide, to look at the evidence to decide whether or not it was a trial. But that doesn't mean that one looks at just at the directions order by itself, and that anything that's done subsequently to that by the court itself is to be disregarded in interpreting the order. It's not as though this is for example, an Act of Parliament that's been passed, and that anything that MPs or even the government says afterwards about the intention of the Act has to be disregarded. If the matter is not clear-cut, then if the matter is not clear-cut, then of course the parties are entitled and will, as a matter of naturally, look to see what else the court has been saying. That's the first point. The second point is he suggests I should make mention in 66 a minor point. He says that the causeless wording was held not to be relevant in Picard. Now, in fact, Picard just lists that as the arguments to be weighed on one side of the balance, and then he decides on the other side to be weighed at whether it was a trial or not. He doesn't say it's irrelevant. He just mentions it as one of the arguments for it. But that's a minor point. The more substantive point is the question of whether, in fact, sorry, this is the mixing up in my submission of what is supposed to be an objective test and what's supposed to be a subjective test. Because he seems to be saying, this is, I'm looking now at the last sentence of paragraph 67 of his skeleton argument. He says he says against the trial fees, he says this reason is not given in the evidence in support of the application of Mr. Stavridis. This is the application for relief from sanctions. And it's true that reason is not given. Mr. Stavridis merely says, because that's what he was told, is that the view of his solicitor at the relevant time was that this was not a trial, although Simmons had written them saying that it was a trial, and she disagreed. But he didn't say why, because he didn't know why. And if you're saying, well, why didn't he probe further? Well, perhaps I ought to just, but cut me short if you don't want me to digress. I mean, the old CPR 3.9 used to distinguish between what when the litigant himself was at fault and when it was the fault of the lawyers, and the latter being an important mitigating factor if it was the fault of the lawyers but not of the litigant, about whether this sanction should apply or not. That was abandoned in the later version for good reason, because I don't.
Well, I think we all know what the reason was.
Yeah, but of course, but it did have the rationale, the justification though for it. The positive justification was, well, if the litigant in those circumstances has got bad advice or been completely misdirected,
Then they've got their alternative.
yeah, to
remedies.
sue. But the problem with that is that, of course, it then means that whenever a question of that nature appears on the horizon, the lawyers are going to start acting defensively, and it's quite difficult to get when you're under extreme time pressure, because this application was made only on the day before. I mean, perhaps I should just explain the timetable.
Well, we know the timetable. We're
Yes.
very clear about the timetable because it's central to
Yes,
the,
but
the
the key
judge's findings, and so we've got that firmly in mind.
No, but the judge has. My point was just this: that the judge has criticised the lateness of our application, but until we received a copy of the Skadden argument, which was, I think it was exchanged slightly in advance of ours, but it was only on the Sunday evening before the hearing, which was on the Wednesday. We didn't know what stance they were going to take.
Well, you did, because you'd been refused the extension.
No, sorry, I'm not talking. We've been refused the extension.
Well, you'd asked for a further extension following the
Oh,
3rd,
yeah,
the 3rd
yes.
of June, and you'd been refused, so you knew precisely what their stance was. Or am I misunderstanding which point you're directing that to?
Yes, no, yes, that's absolutely right. They had refused an extension, but that could have been just because they were fed up and they wanted it quickly as possible, and they didn't want to give any more extensions.
But
They
an
had
application-
mentioned about it being a trial.
But an application could have been made at that stage, couldn't it?
It could have been, absolutely, but we were still proceeding on the basis that this was a trial.
A hearing.
And that's the key point, and that's the key point between the objective and subjective distinction, which I'm going to come to in a minute.
Presumably you're not disputing that it's an objective test as to whether it's a trial or not.
Absolutely, that's my point. It's an
Right.
objective to establish it, and that's why I tried but failed to persuade the judge, and I was effectively Decolace was criticised for that in terms of his judgment for not wanting to mix up the two. My position was that this was a two-stage test. The first stage is to establish objectively whether or not this was a trial, and only after doing that, if you decide that it was a trial, then we would apply for, or then the application for relief from sanctions, if it was made, would be considered, and the evidence would be considered, and that could be subjective evidence, and the subjective evidence could include what Mr. Stavronidis' lawyer thought, and why she thought it, which we didn't get to the bottom of for the reasons I was just indicating, because she was being quite defensive at that stage. But anyway, I don't want to give evidence, and certainly always privilege. I'm just saying lawyers in that situation often become quite defensive, and certainly slow, and want to give considered responses and careful responses rather than trying to say immediately what they did, particularly if they may have made a mistake in the way they reasoned, whatever it is they reasoned in this case. That it
The
wasn't a
judge was
trial.
simply faced with the situation that the judge was faced with, which was that was the timetable, no application was made, and that's what the judge had to deal with.
That's right. But in our submission, if no application was made, if it was not a trial, no application needed to be made. That's because there was no rule which had been breached which would lead to the sanction of barring, or a sanction which would bar the evidence. And in fact, in our submission, there was no sanction imposed anyway. The application for relief from sanctions presupposes that there is a sanction that can be
So
relief
what's
can
the
be sought
point
against.
in having a time for evidence to be filed?
So
Because on yours, you just made a submission that if this was not a trial, as you submit, no application needs to be made. In which case, Mr. Ashworth case, he was wasting his time in setting out a timetable because it didn't need to be complied with.
No, it did need to be complied with because first of all, if the deadline was missed, and it was quite a tight timetable, I think, my learned friend concedes, but the timetable, if the timetable was not adhered to such an extent, it got so close to trial before the evidence was submitted, and in this case it was a whole week. I emphasise, but in any case, it was so close that in fact it would be unfair for the parties, and certainly for the other party, to have to deal with it at such short notice. Then the natural solution would have been to adjourn and make the party responsible, in this case the applicants, pay all the costs thrown away, which can be a pretty strong incentive, particularly when the costs are being incurred by Simmons and Simmons, who had put in very large bills already up for each piece of work that had happened up to them. So there's no doubt there's a strong financial incentive not to allow that to happen. And you can see, in any event, from the evidence of Mr. Stavronidis and indeed the email setting out the timetable of his lawyer, Lorraine Lancaster, that it wasn't that they were sitting back doing nothing, but the whole thing just took far too long. Mr. Stavronidis has not dealt, as he said, with 57 days a year before. He had no experience of it. He was going to try and do it himself.
I'm sorry, are you slightly drifting into a different
I am
ground
going into
here?
a different point, yes.
So have we finished on ground one? Just so I can keep
No, we haven't. No,
right. Okay, can we? Well, I'm also conscious of the time. I mean,
Yes.
I'd anticipated you'd be comfortably finished before the short adjournment, and we're still on the first ground of 4.
Oh, yes, so that's what we have, to some extent, swept up a lot of ground 4, and we've also dealt with ground 2.
Fine.
And
Well,
we've
that's
touched
very
on ground
reassuring.
6.
No doubt for Mr. McGee, who will be looking to have his go in due course.
Yes.
Very well.
No, I didn't.
All
I
right.
didn't want to do that at all. But
So what have we got left? So far as ground 1 is concerned?
so
I'm going to take
so
us to
the fact
Pickard, I
that
think.
so what I'm saying is that the last 2 sentences of paragraph 67 are simply wrong. The reason is to be determined objectively, and the objective determination is what would the objective interpretation is as follows. It's whether the decisions and steps taken by the court which determine whether or not a hearing of the trial. It's how the relevant litigants or court user assumed to be. I'm sorry, I'm actually reading from it. It's assumed to be literate and well informed about court practice, or to be relying on their lawyer, would reasonably interpret the decisions made by the court. Would reasonably interpret the decisions made by the court as they have been communicated to him by the court. I emphasise that last point, not because there's any doubt about the actual directions, although that's obviously communicated very clearly, but about the subsequent matters, in particular the trial fee, because this is what I'm just focusing on at the moment, the trial fee. And so that's the objective test. It's how the decisions are made by the court as communicated, because obviously the decision is not communicated, it's meaningless. But it has to be how it's reasonably interpreted by a reasonable or well-informed litigant. That's the objective test. And on that basis, one can assume that as Mr. Stavronidis was relying on his lawyer at that period, and as lawyers, and indeed the as it's said in the evidence, she was a litigation partner, and as litigation partners are very conscious of the need to pay trial fees very promptly. But before the deadline, because the consequence is pretty draconian, because it's an automatic strike act if you fail to pay on time. And of course, that means it can mean negligence action and something else. So of course, they're going to be extremely careful about that. So it's quite likely that she, in assessing her decision or her view, informing her view that this was not a trial, it's highly likely that she would have looked at the file and seen, particularly as the trial fee would have fell due on the 20th of May, which was right in the middle of when she was on the record. So so in my submission, she would definitely look at that. That is the sort of objective evidence reasonable litigant and his lawyer would have had in order to make a decision.
We have your point on that.
And by contrast, the lawyer's subjective view are only relevant if he has to apply for relief on sanctions. But if it's not applied, it does not. And Mr. Savanides didn't know the reason because there wasn't time to probe it.
If it's an objective test, then it doesn't really matter what Mr. Savanides or his solicitor thought about what was required,
As far as establishing whether it's a trial or not, yes, that's right.
as far as establishing whether 32.10 applied.
Yes, except to the extent that it allows permission to be given if otherwise, yeah, which does engage the test. 32.10 itself, as in a mechanism, but it's been interpreted by the court, just to be clear, 32.10, the saving provision within 32.10 has been interpreted. If you ask for the saving provision, you're asking for relief on sanctions. I don't think there's any dispute about that. Now the second error, though, which I did really want to go on to, is this distinction that he's drawing between the court slap and the court, which you cannot, as far as I'm concerned. Our first point is this: that if the court had issued a fee notice, as it should have done on the 31st of January, when it gave the notice of the hearing itself, and it called it only the notice of the hearing, and that's in the bundle at that is in the bundle. I think it's at the very end of the full bundle. But anyway, that notice, if they'd said it was a trial fee, then that would have closed. That would have ended the argument. Because there is in those circumstances no way that Mr. Stavronidis or Decolace or their lawyer, Miss Lancaster, could have said, "Well, this isn't a trial. I thought it wasn't a trial," because it's quite clear that the trial fee was levied. Was notified, and if it wasn't paid, then the case would be struck out anyway. And if it was paid, then they clearly knew, not only because they received the notice, because they actually paid the fee. So either way, that would have been absolutely decisive. But conversely, the absence of any such notice, or at a later date, and the deadline for paying would have been the 20th of May, so it had to be well before that, would have led a reasonable application in these positions to conclude, in the absence of any clear contradictory evidence, that the final hearing was not being reclassified by the court as a trial, but continued just to be a hearing of its application. I say just continued because that was the position prior to the directions order, i.e. prior to mid-January, or the 24th of January to be precise. Now, if one looks at CPR 2.4 and 2.5, I mean, that's the bundle. Perhaps I can just take you to that quickly.
CPR 2 point.
Oh, sorry, I didn't.
It's not in.
I've got perhaps. Sorry, that is not in the bundle. I'm sorry. I apologise. I don't. Does anybody have the white book? I apologise.
It's out of date, but probably good enough.
I don't think that's changed. I don't think that's had a change since 1998. It's a pretty uncontroversial provision. But
Yeah,
for the
might have to take one. I'll have another out of date one. Big version.
I'd say for the purposes of those two rules taken together, each of the following things are acts of the court. First of all, a decision to classify or deem the forthcoming here to be a trial. That would be an act of the court if a decision to that was made. And second, the communication of that decision to the parties. And that would include the communication that it would include by way of drafting and sending the fee notice in the correct sum, because that necessarily arises from the decision to classify it as a trial. So I'm saying both those two things are acts of the court.
And it turns out the rule has changed. because the 2021 is not anything close to what you've just been reading out. 2.4.
Well,
2.5,
I'm just going to get it on
2.5.
Where the rules require or permit the court to perform an act of a formal administrative character, the act may be performed by a court officer. A requirement that a court officer carry out an act at the request of a party is subject to the payment of a fee. Is that the part you were taking us to?
Yeah, I'm just trying to check that that's really up to date. I am now looking at the latest version. So 2.4 says where these rules provide for the court to perform any act, except whether an act rule or practice action provides several others, that act may be performed by then it says various judges and legal advisors. So that's what, so 2.5 says, so the 2.4 allows the court to provide any action. So a judge, so that establishes that, in fact, I would submit as a starting point that even the judge can effectively draft and instruct his staff to send out a fee notice, a notice of hearing. And I think in the county court, that's exactly what some judges do. So certainly they send out the setting of a.
I'm sorry, I don't see how this helps us at all. All this does is give the power
Yes,
the court staff
exactly.
or to carry out administrative functions, or the judge to do it if they choose to do it in lieu of the.
Yes, but
So
my
why,
point
why
is
does that? How does that help us?
what it's saying is therefore that one can't distinguish between the two. You can't say.
So your submission is that the fact that it's interchangeable as between the judge and the court staff,
Yes.
that is an indication that you have to regard the court, if I can put it globally, as is your
Exactly.
submission. Fine, I've
And,
got your
and
submission now.
therefore, when the court desisted from issuing, I could say decided not to issue a fee notice on the 31st of January, it was as if the judge himself had said. So that you can't
It's not-
separate. No, I agree. If actually, if
I
the
don't think
idea
that's
was
what
to
it
look-
says.
No, it's except that he has to. No, but he's saying, but this is the point. It's saying if it's a court officer is only allowed to have it delegated, a duty delegated to him, if it's purely of an administrative nature. That's what 2.5 says. A formal or administrative character.
We have
But if
have
the-
your submission on it.
Yes, so it has to be of a formal. If it's of a formal or administrative character, then it can be delegated by the judge to the court officer. But if it's not, if it's more than that, if it's either purely a legal decision or if it's a hybrid decision, it's got an element, as most things do of administration, then the judge has to be involved. Because this clearly, as
There is
I think-
absolutely no authority that a judge has to be involved in the sending out of a fee.
That's not my point. The point is that I'm not. This is not a suit against court service for breach of some sort of
No, I
statute.
know it isn't, but I'm just not.
No, but no. The
I
question
thought
is
I'd got your point a moment ago.
No,
I seem to have lost
yes.
it again.
My point is this: that the inference we're talking now about, the inference is correctly to be drawn by a reasonable litigant objectively on the communications he receives from the court about.
Well, I don't see why it goes further for your purposes than for you to say it's supporting evidence or it's in supporting an argument that this was not a trial, that the normal procedure didn't, consequences of it being a trial, namely the sending out of the fee notice, didn't happen.
Yes, but I am saying that, to be sure. But I am saying a bit more than that, because I am also saying, and indeed I do in the original closing argument, that the judge himself was in communication with his court staff.
Well, we don't know what was said.
We don't know what was said, but what I'm saying is that in the working out of that directions order, we can see from the emails that the court staff.
We don't have the emails.
Pardon? The emails are in the bundle.
Oh, sorry, but I thought you meant
The
individual.
sorry, these are emails that the court staff have sent to
So what are you referring to, please?
Sorry, I thought you were talking about emails between the judge and staff.
no emails. No, I'm only talking. My point is about purely communications between the court taken as a whole and the litigants, and I'm saying you can't draw a distinction between the two.
Well, we understand that point.
And I'm saying even as a matter of evidence, to the extent that that's relevant, although I say my main point is how it's communicated. But there was nothing to put it. Let me put it negatively. There was nothing to indicate that this was simply the matter of the judge failing to be in contact with his staff, with the court officers. That it was sort of breakdown of communication, because the email evidence shows that the court officers were in contact with the judge with the working out of that order, and therefore even that assumption shouldn't be made. And therefore, I'm saying that is a powerful indicator. This whole area of court fees is a powerful indicator. I'm not trying to.
That I understand completely. You're
Okay.
saying the directions are made, that then goes to the administrative staff, who then do the appropriate workings out of that directions as it relates to them.
Yeah. But they don't.
And nothing happened that would indicate to your instructing solicitors that this was a trial rather than a hearing because they didn't get a fee
Yes.
request. I'm not sure how much further you
Okay.
can take it.
Fine. No, I'm only doing that because Mr. McGee has pushed quite hard against this point. But anyway,
Well, I
think I've
understand
done-
it. He'll have to work hard to
it.
sustain it. No doubt he will.
Yes. So that does cover. We dealt with the positive. So that covers really all of ground one, except for Kinsley and the Metropolitan Police. I don't know if I need to take you through that.
That's
case.
right of you.
That case establishes the following. I mean, that case establishes that two things. Which I mentioned in the Schedule model the concept of doubtful penalisation. I don't know if you wish me to explain that. I mean, typical doubtful penalisation, i.e., that if there's a penalty involved against a party, then the rule or the order or whatever it is that's being enforced against them, if there's any ambiguity in it, and therefore any doubt about what it actually means, that doubt should always be construed in favour of the person being penalised. That's the principle.
Deal
It's a
with it.
well-known principle of statutory construction, but you've already accepted that the correct interpretation of Rule 332.10, namely that it carries with it an implied sanction, has already been established by the authorities of this court.
No, that's not my point. My point. I'm sorry. There's an intermediate step, which I was just going to say. The intermediate step is this: that whether if a hearing is classified or reclassified as a trial, then because of all the stricter rules that attach to it being a trial, and 32 is only one, CPR 39 is another, CPR 29.
What is the legislative provision or rule which you are saying that the principle can apply to? It is a principle of interpretation of legislation, and it's a well-known principle.
Yes,
But at the moment, given that you don't seem to be relying on it with regard to the interpretation of 32.10, and for good reason, what other rule do you say that this principle can apply to?
I say it applies to the totality of. If we're talking about the interpretation of a court order, and we're talking about the totality of the communications which relate to the meaning of that order, which were communicated by the court to the litigant in question, and and Kinsley is my authority. I should say to some extent, and perhaps I should just make this point, just in case I run out of time, even in the Yes case, which I was going to come to shortly, at 31, and this is, I think it may even be cited by my learned friend, but anyway, in the Yes case at 31, it says, importance of clarity in the procedural framework to be followed by the court users means that the hurdle for an implicit sanction must be a high one. That is another reflection of that principle. It's being recognised, so it's recognised by the Court of Appeal in that case, but more subtly, it's recognised by the Court of Appeal in the Kinsley case, because in that case, it's not just the simple matter of a statute being interpreted. In fact, it's not a matter of a statute being interpreted at all, it's a matter of an order of the court being interpreted. And the point is that the Court of Appeal takes the view that one is entitled to look at the totality of that evidence. And even though it was done it was considered as part of an application for relief on sanctions, they interpreted it objectively as well. So it would apply anyway, in my submission. And that's why Kinsley is of some importance. And it is a reflection of the same underlying principle. And one would expect, because in a sense, what I've just stated, it's wrong for a person to be penalised if there's some doubt about the statute or the court order under which he faces penalisation as to what it really means. That's my underlying point. But perhaps I should just take you, if I may, to
that point I understand.
and therefore it's likely to have broader application than just a statutory interpretation. But if I can just take you to the to that case, which is
Tab 7.
tab 7. Now I have there, given the shortage of time, I'm just going to take you through a bit very.
Well, you've taken us to two passages in your skeleton argument.
Yes, but
Paragraphs 48 and 61.
yes, well that's the reduced to the minimum, the real bottom line. Yeah, that's right.
That's helpful, isn't it?
But I
On
have
their side.
in the bundle itself, I've highlighted several of the passages.
Yeah.
Which I think tell the story of how of the factors which were weighed and which were relevant. I perhaps will have to
We can
unless you'll
read
tell me
it.
what-
We can read it.
Yes. Okay. Thank you.
And you've helpfully marked it's marked up by both of you, so we can.
Yeah. So the just. If I may then, just to sum up, 48. Had he been provided with the 20 days, probably in my view, the judge would have concluded that there was indeed room for misunderstanding, which should be resolved in Mr. Kinsley's favour. That's at paragraph 48. And at paragraph 27, this is a different judge. Paragraph 38. It seems to me reasonably possible that the judge's words could have been interpreted to mean that Mr. Kinsley was protected from the effect of paragraph 3, provided that he made a fresh application to adjourn the proceedings generally. So that's really those are the two bottom lines.
Thank you.
I do emphasise this, it was an application for relief on sanctions.
Yes.
And so the subjective element doesn't, but my point is it doesn't really play a major part in it, or perhaps any part. And anyway, the penalisation principle is clearly engaged there. So to the extent that it's authority that the doubt penalisation principle is engaged or can be engaged.
Well, your point, as I understand it, as you just put, is that the position is that it would be wrong to be penalised if there was some doubt as to the meaning of the order, and your whole case is there was considerable doubt about the meaning of the order, and the objective bystander would have regarded this order as leading us towards a hearing, not a trial, and therefore, because that was a reasonably, on an objective test, a reasonable doubt to have, that your lay client should not have been penalised.
Thank you, Martin. So shall I move on swiftly?
Is that right?
Yes, no, that is
Right.
Thank you. If I can move on to ground 6, which is in fact the last, or almost the last ground I need to deal with, although there are one or two other points on ground 4, which I'll come back to at the end, because I really do need to deal with ground 6, given the shortage of time. And ground 6 is concerned with the assessment of the judge that he took as good law what was set out in the White Book, and the White Book refers to the Sayers case and that line of authority which is talking about appellant's notices and later on with the Altamart case, respondents' notices. and saying that if you're out of time in putting in your case notice, which has to be within 21 days at the moment, then you have to apply for an extension of time, and that amounts to relief from sanction. That, in other words, it's an implied sanction there that will be cut out. And he says, well, that the judge's view was that applies generally, that principle can be applied in all cases. Well, he seems to suggest, as relying on his interpretation of what the White Book says, that applies to all cases where you have to, where you need the permission of the court to go on. Now, the judge, although the judge, I both gave him a copy of that and in my closing argument referred to the Yes case in some detail. The judge, he does not seem to have accepted, maybe he disagrees with me, maybe he hasn't had time to read it, I don't know, the basic implications of Yes, which follows on as Lady Justice Falk said when given permission to appeal, which follows on from the previous Lufthansa case. I mean, taking the two cases together. But the Yes is the second case, and it's a bit clearer on this specific point. That a sanction has to be either expressed in an order or statute or some rule of court or some practice direction. If it isn't,
Well, can I be clear? Is it your submission that the judge, on the assumption that it was not a trial, nevertheless applied an implied sanction? Because at the moment, that's not how I read the judgment. Rather, how I'm reading the judgment at the moment, and please correct me if you think I'm wrong, is that his reasoning was different. His reasoning was not that there was an implied sanction. The implied sanction was his first reason. Namely, he says there is a trial, therefore 32.10 applies, it's established that's an implied sanction, therefore you have to go on to relief from sanction. But then his alternative reasoning is, if there's no trial, 32.10 doesn't apply, therefore no implied sanction. But in considering whether to exercise discretion on an out-of-time application for a retrospective extension of time, the same criteria need to be considered. Now, do you dispute that reading of the judgment?
I don't think it's clear, but perhaps I can take you to the relevant parts of it.
Yeah.
I mean,
Paragraph 59 of the judgment.
yes, starting in paragraph 59, when he says, the last sentence of paragraph 59, it follows whether it's a trial, whether it's an out-of-time retrospective application, Decolace has to engage with a three-stage process that is familiar under Rule 3.9. But that, in our submission, that's wrong. It's not consistent with the Yes case. This isn't. There can't be an implied sanction.
Well, do we need to look at Yes then? If you say that is wrong because it doesn't follow Yes, which is a Court of Appeal case,
yes,
and so binding, you better take us to the relevant part of Yes, which undermines paragraph 59 of the judgment, I think, please.
So in that, in fact, the key paragraphs, I think, are 26, 31 and 33. This is actually, perhaps I can short circuit it by just referring you to paragraph 49 of my statement argument,
49 of your scout mark.
which is at page 15 of the core volume.
Thank you.
And I just summarised there in A, B and C the key passages that I'm relying on. Would the court just like to read
Just
those?
reread those.
So your submission is that in effect, the judge did apply an applied sanction and he was incorrect to do so because there is none in the rules.
Exactly.
Okay.
But what you don't set out in your paragraph 49 is what is said at the end of paragraph 25. Yes, which is at tab 17 of our parties bundle. Where Justice Burrs explains that the ethos of Denton applies even when relief from sanctions is not engaged. And isn't that just exactly what the judge has done here? He's applied the ethos of Denton to the circumstances which apply in a case where key witness statements were served a week before the final hearing.
But that's not what this judge, which we're appealing against, says. Though what he says is, it follows that whether this is a trial, whether it's an out of time retrospective application, Decolace has to engage with the three-stage process. That's what we're saying is wrong. I was proposing to come to the more general, broad brush point about the overriding objective and so on in a minute, in the ethos of Denton. But he's saying that it specifically applies there because it's an out of time retrospective application.
If he had said that you had to engage with the ethos of the three-stage process that is Denton, would that have been the wording at the end of 59? Would that have been all right?
He's saying that is why it can be said that the ethos has applied even when it's not engaged. That's all he says, though. But that's not the thrust of his judgment. I mean, that does open a
If
possibility.
you're going to take that point, I'm going to direct you to paragraph 32, where he makes the same point, perhaps more clearly. At the end of paragraph 32, which is on page 363 of the judgment, he says, 3.9 either applies or it does not, and if not, then the application will be governed by the modern approach to the overriding objective, which will, in appropriate circumstances, bring in the ethos of Denton.
Yes. No, I accept that, and that's absolutely right. And I was going to deal with that next, but I first of all wanted to overcome this primary hurdle, because the primary hurdle is that his starting point is in my submission mistaken, because he says he refers, having referred to the White Book and what the White Book says and set out his interpretation. That it says he then says it follows the following. So in my submission, that's simply in other words, he's saying that there is a sanction, and he's saying that has to engage. He doesn't say that there's any doubt about it. He says it has to engage, and I should go. And if you look at paragraph 60, it says Decolace has not done that, which in my submission is even more mistaken, because he says. There is no at the bottom. There is no evidence dealing with the matters which have to be considered by the court in 3.9. Anyway, but he's saying that because the witness statement of Mr. Stravonidis, he says in the second line, is simply reciting the facts. But of course, the whole ethos of PD 57AC is that you're not supposed to put the words into the mouth of the litigant. And you're not supposed to overlaw it. You're not supposed to put in commentary and interpretation. Now, I appreciate that 57AC, which is what the court Decolace's downfall in the first place, is only talking about trials, or was normally talking about trials, unless he would say the court orders otherwise. But its focus is primarily on trials. But the principle behind that, i.e., that you shouldn't put words into a witness's mouth and so on, are just wrong. I mean, even if it's sometimes helpful to put words for a lawyer to put words into the witness's mouth. And even if it's sometimes right to, or it's helpful, convenient, to add some sort of commentary, just because it speeds things up, to actually say, if you do the opposite, actually to kind of reverse that and say, if you haven't indulged yourself in that kind of relaxation to some extent, then it simply isn't evidence anymore which deals with the matter. I mean, that is, in my submission, seriously at fault, and it does indicate how the extent to which the judge had misdirected himself on these points.
So you were going to then say something about the overriding objective, I think.
Yes. Well, you'll see in the authorities bundle that my learned friend has relied, in fact, on the authority of which comes after, yes, authority of Vegas, which is under tab 18 in the authorities bundle. I'm sorry, it's actually the first page of Vegas is actually
It seems to be
what
missing.
It's in the previous tab.
it's just behind, right?
Previous
Yeah.
tab, double paged.
And he relies in particular on paragraph 58. When he deals with that, and this is what he is saying. But that paragraph is saying that in that case, there was no. He's accepting the yes decision that there's no implied sanction in 17.2. This is another case where someone was supposed to apply to set aside an amended particulars of claim. It was well outside. I mean, it was, I think, more than a year outside the 14-day period in which you were supposed to do it. And it said that this is a subject. He accepts that, although it says you've got to do it within that time, it's not subject either to an express or an implied sanction. So he's accepted. Sorry, this is the Court of Appeal. When I say here, it is Lord Justice, but it is the whole Court of Appeal who are agreeing with this. And that it is nevertheless, he says, as indeed Lord Justice Burst said, it may still be relevant to consider the matters reflected in the three-stage test. But unlike application for relief on sanction, the matter should be approached on the basis
be approached.
Sorry, thank you. Yeah, the matter should not be approached on the basis that the starting point is that the sanction has been properly imposed and complied with it.
In connection with that, do you want to? Perhaps we should look at paragraph 69 of the deputy judge's judgment in this case. Where after considering the three Benton elements, he says, "I have therefore concluded that I should not grant relief." You're going to suggest that it might be suggested that in saying that he's starting from the starting point that there is a sanction,
Yeah,
but he shouldn't grant relief.
no, that was my I'm grateful. I was actually looking at a different paragraph, but that's 69 certainly reinforces that point. So his starting point is wrong. His starting point is the wrong starting. And as you can see, it's quite an entrenched view, as you can see about his comments about the fact that we never produced any evidence anywhere. In order to assess the relevance of the overriding objective, one has to really stand right back and take an overview of the whole case. And one can't start with presuppositions. There are a couple of other points I just need to make on that last point. If we are moving to the last point, and I don't need to deal anymore with the effect of yes and so on. first of all, the 32.10, the whole of Part 32 covers Part 32 as a whole covers evidence, particularly witness evidence, although there's a few references to documentary evidence, and it covers evidence both at trials and not at trials. So when 32.10 says that the sanction in 32.10,
Sorry, could you help me? Which ground you were addressing now?
this is this is still ground 6.
Right.
And it's being said, as I understand it, by the tribunal, that even if the judge was wrong because of to rely on the White Book and or interpret the White Book in the way that he has, then he still has the right to resort to the overriding objective and the application of that. And my points are, one, that the point that your ladyship just made, which there is other indications of as well. Secondly, though, that 32.10 in a part which deals.
I'm sorry, I don't understand the relevance of 32.10 to ground 6, because ground 6 is on the premise that there is no trial, therefore 32.10 doesn't apply, there's no implied sanction, and it's a pure question of discretion as to an extension of time retrospectively.
Yes, but it's when you say pure discretion, but in my submission, 1.1 is not actually a rule in itself. It has to be the overriding objective has to be applied when the court is making orders under other provisions of some sort or another. It's not just a sort of free-floating thing. I mean, of course, there are plenty of other. It's a statement of principle in itself. I have not found any examples where it's just said, oh, we don't need to, or there's no need to mention any rule. I mean, sometimes it's obvious what the rule is, but there always has to be some decision of the court that one can apply the overriding objective to. And of course, the CPR gives huge range of that. But nevertheless, my real point in making this submission is that the judge did not identify which particular rule he was relying on, or it needn't be a rule; it could be an order of the court or some other principle of common law.
But sorry, on this hypothesis, what he's considering is your client's application for an extension of time.
Yes.
Under Rule 3 point whatever it is,
Yes.
it gives the power to extend times under court orders. So the CPR was plainly engaged by that application, was it not?
Yes. That's it. No, but it isn't. If one accepts,
Are you submitting that the overriding objective is not engaged on an application to extend time?
No, of course it can. It is engaged. The reason because an application to extend time it would be engaged because if you accept that there needs to be an application because the court then has to grant permission. It's the granting of permission or the refusal to grant permission which is then subject to the overriding objective.
I'm baffled then. Is your submission that there was no application to extend time? Because I thought
your
that was
submission is
there
they
was an
didn't need to be.
No, I'm saying there was an application to extend time because that's the way the judge clearly was thinking, he indicated to us, and he's effectively inviting us to make that application. We did, but our primary case remained that. But yes, we did try that. But if you're saying by doing that, that then allowed him to apply the overriding objective to that would be the rule. Is in my submission wrong because he's Denton. Yes, is only saying that the principles of Denton apply in a general sense. He's not saying that what he's saying is you can't use 3.9 unless it's an application for relief from sanctions or an implied sanction. But if it isn't an implied sanction, then 3.9 doesn't apply. I mean, yes makes that very clear. That distinction is very clear, and therefore it must bite on something. And I don't dispute there are plenty of things that it could have bit. It bites on. It might bite on. For example, it was open to the judge to say under 32 he could have just excluded the evidence. He didn't actually need to, but he would have needed to spell it out. If that's what he was going to do, he needed to spell it out and say the CPR allows me simply to exclude the evidence of the 32. I'm applying the overriding objective to that, given the fact it's so late, and I've decided that I am going to exclude it. If he'd done it on that basis, then well, then no doubt we would have had arguments. But anyway, it then would have been clear. But he hasn't. In a way, it kind of merges into the point that's already been made. Because his starting point is that the sanction is properly in place in the first place. He feels no need to do that, but that's just exactly what the Vigus case is designed to stop. You can't say if there is no sanction, to say, well, I'm going to proceed on the basis that there is a sanction, and therefore 3.9 is applied, and then I'm going to apply the overriding objection to 3.9 in the way I interpret and apply 3.9. That approach, in my submission, Lord Justice Newey makes very clear, is not the right way to apply the overriding objective. You have to start, and in my submission, either it has to be obvious which rule it is that the overriding objective is applying to, or it should be stated. And it could have been stated here, but it wasn't, which just, in my submission, suggests that the judge didn't have that in mind in a broad sense, and his judgment can't be interpreted that way. I should point out that there's no respondent's notice saying that this should be upheld on other grounds. So it is very much limited, and my learned friend is very much limited to what's in and what can be extracted from the judgment itself, because he doesn't raise this whole issue as a separate point. But what I was going to say, Lord Justice Arnold, if I may, just on 32.10, my point was simply this, that if 32.10 does go to the draftsman of that, does make a distinction between pre-trial and trials as far as admissibility of late evidence is concerned, or the draconian effect, then is it right to use the overriding objective simply to override that distinction which the draftsman has clearly thought about and consciously decided to make? I mean, of course, you could say, well, the overriding objective is a matter for the judge and he can decide whatever he wants. But in my submission, that's not the correct approach, if that's what he was doing, which I don't think it was. But if that's what he was doing, that wouldn't be the correct approach. He would need to consider, well, this is clearly an important distinction. Is it right, given that the draftsman's made that distinction, to how should I apply the overriding objective to it? Of course, it would be a different matter. I should say it would be a different matter if the witness statement had been presented, for example, at the door of the court at the beginning of the hearing, i.e. there had no time. This was a weekly call. It wasn't so close to the trials to be an obvious abusive process or something like that, where there might be some other common law engaged. There was still a week. It was. We accept it was obviously late, and my learned friend uses the phrase "very late," and he says it was only one day before scuds and arguments had to be exchanged. Although, of course, he could have done a scuds and argument and said at the end of it, "We've only just got this yesterday, and I reserve the right to put in a supplementary stuff in the next few days." I mean, I'm not. All I'm saying is it's not so serious as to be an abusive process or anything of that nature.
All right, you have your point on that.
So that I think.
No, that's very clear where you are on ground 6. Thank you.
So the other point I just want to make very briefly on ground 4, and then I will sit down. I appreciate the court's indulgence. Just on point 4 on res judicata. It's except the reason why res judicata is important. One, because of the question of how serious a set of issues this was, and how important these issues were, and whether one can infer from that this should have been a trial. What needs to be taken as an indicator, which I think was the point made by the court to me earlier. But so there's a separate point, and that's whether the case of Picard, right? Because as you will see in his judgment, the deputy judge relies very much. He particularly cites. There's no other authority which he was taken, given the Portelux case doesn't apply, but Picard does apply. in the sense that it says that it decided it was a trial, and it said one of the criteria because perhaps I could just take you to that case, which is in the authority under at 11. Under tab 11. And it's actually, I mean, the key part is at paragraph 32, which is on page 240.
Sorry, paragraph? Which
Sorry, 32 and 33, sorry,
Thank you.
not just 32, 32 and 33. That's the key part of his judgment. But you'll see he's saying, first of all, he's saying in 32 that there's several factors he takes into account. Although I have to say none of those other factors are particularly relevant to this case, except that they distinguish this case from that case. In that case, the litigant concerned continually made applications to the court and then failed to turn up or follow them through. I mean, those are the sort of things which he cites early on in the judgment. But the key thing then is, having noted 32, is going to invite to look at 33. That's the point on which my learned friend relied, and indeed that was a point which clearly influenced in an important way the deputy judge below. And my submissions on that are, first of all, what my learned friend, in fact, has referred to, and indeed for slightly different purposes, relied on the case of SCF Finance, which establishes that you can, in an interim application, an interim hearing of an interim application involving what they call a waiver injunction, still create a raised judicata estoppel, and that was to do with the matter of property. So to that extent, it's not that immediately blurs the bright line that in fact that possibly the Deputy Judge Baldwin in the Picard case was trying to draw. If it was a bright line, but I'm saying it ends up being a rather blurred line. The other cases I refer to are the Midland Bank case, and also which are at the end of the Midland Bank case, which is at the beginning of the bundle, and the case of Osman, which is at the end of the bundle. The reason it's at the end of the bundle under tab 20, the reason that the Osman case, that's our ex parte Osman against the government in prison. The reason that that's at the end of the bundle, together with the subsequent case, is that because it's cited in Spencer Bauer, which my learned friend referred to in Staten Island and indeed in the bundle immediately before that. Spencer Bauer basically says that Midland is wrong and the Osman case are both wrong, because they do establish race judicata. And he's saying that they shouldn't do because they're matters of procedure. There's no and there shouldn't be a race judicata without a procedure. My submission is on those two cases, they're really to do with the law of evidence. And so it's not really a matter of procedure, but it's more evidence, which I agree overlaps. But the real point is that the ability of an interim, of a final hearing of an interim application to set a raised judicata is much more widespread than just the Morava Junction case, although that is pretty close to our case, and that these examples show that. And also, I've put down the immediate case after that, which is which you'll see under tab 21, R versus the parole board ex parte Smith. And the reason I do that is because Spencer Bauer himself says that this case shows that his approach is justified, and that the cases prior to that were therefore by implication wrong. But in my submission, it doesn't show that. He's saying that this case shows that you don't create the raised judicata. That's what he's saying. my answer to that is simply this: that it does show. It's neutral. That case cannot be relied on to say an interim application, even if it's dealing with a procedural matter, cannot create a res judicata, because that is dependent on a rule to do with a judicial review under the CPR, namely Rule 52.15, which is mentioned in the case, which gives the court very wide discretion about revisiting the permission it's given for judicial review. And therefore, no res judicata could ever be created because it was always subject to that rule. It's really it comes down to a matter of interpretation. So Spencer Bauer has over-interpreted that to bolster his conclusion, which I've said, which is a fairly technical conclusion anyway. So for those, that's the reason I mentioned those cases, is because my purpose is to establish that there is no bright line between trials and final hearings of applications, interim applications, which have anything to do with res judicata. I mean, if one did some sort of statistical test, no doubt you would find there were more res judicata created by trials than by, but that's no good in my submission. That's no good to try and decide the case here or to apply. Thank you.
Anything else? Yeah. Thank you very much indeed, Mr. Wallman. Yes, Mr. McKay.
Good afternoon, my name is Arnold. I'm conscious of the time. I'm very happy to make a start now.
I think we will do, please.
Of course.
Again, we've had the opportunity of reading your detailed and helpful skeleton argument and looked at the authorities you've mentioned.
I'm very grateful for that indication. As the court's then aware, there are 4 grounds for appeal, but ultimately this boils down to 2 key questions.
Yep.
The first key question is whether or not the hearing that took place last June was a trial. And as I believe Mr. Wallman accepts, that is a hard-edged question of legal fact. It's an objective assessment, and the judge below was either right or wrong on that, and that's a question for this court to decide. However, that question of itself is not determinative of anything. It merely provides the context for the second question. The second question is whether the judge was right to refuse the relief that was sought on the application notice. And the relief that was sought on the application notice was relief from sanctions if necessary and or a retrospective extension of time. That's the application that was made, that was the application that was dismissed. And the question for the court is whether the judge was right to dismiss that. And that is not such a binary question because, of course, it is a case management decision, and therefore there are a range of reasonable outcomes. Different judges could reasonably come to different conclusions on the application. So in my submission, this court is not looking at the matter afresh, it is asking whether the judge went wrong. And there is a limit on the court's ability to do that. Now, I do cite on authority on this in my skeleton at paragraph 77. Mr. Wallman didn't take issue with it, but didn't indicate that the authority was accepted. But the quotation I put in the skeleton is that before they can interfere with the case management decision, appellate judges must not merely disagree with the decision, they must consider it unjustifiable. And in my submission, that is the correct test for the court to apply. Either the judge below must have gone wrong in law, he must have taken into account an irrelevant factor or ignored a highly relevant factor, or he must have exercised his discretion in a way that no reasonable judge could have done. And that's the hurdle that Mr. Wallman has to pass. In my submission, the judge below was correct for the reasons that he gave. The matter on both of those questions. As to the first question, the hearing was a trial for the reasons that the judge relied on. I'll take the court through those. And on the second question, the judge was right to refuse relief. First, on the basis of that it was a trial, that CPR 3210 did apply, and it was appropriate not to grant relief from sanctions. But the judge expressly canvassed the possibility he was wrong on the first question and said, if I'm wrong on the question of whether it's a trial, I nevertheless have to consider how to deal with the fact that I have out-of-time evidence. And I have to consider whether or not it is proportionate to exclude that evidence. The judge expressly did so, and he concluded and reasoned why. He said it was proportionate not to grant the relief sought. But again, I will come to that.
Have we got somewhere in our bundles, the application?
The application notice for relief.
Yes.
Yes, that's in the supplemental bundle
Yeah,
at page 101
thank you.
and 14. This is also a point where I can correct a minor error in my skeleton as well. Just for the court's note, at paragraph 23, I state that the second day of the hearing was Wednesday the 18th, it was Thursday the 19th. It's not an important point, but we see here the date of the application notice was the 19th of June. So this was the application issued in the morning of the second hearing day. And at box 3, we say, what order are you asking the court to make and why? The order sought is to retrospectively extend time for filing and serving the 12th witness statement.
So your point is that he's asking for two forms of relief. They're not expressed as alternative, but in fact they are alternative.
Yes, so the logically in my submission, the second one is first. If it's a trial, there's an automatic sanction under 3210, then relief from that. But a point that I'll be picking up, but as Lord Justice Arnold indicated earlier, even if there was no sanction applied, the judge nevertheless had to work out what to do with the out of time application, and in doing so, had to consider whether to retrospectively extend time. And that's the application that was made. I'm conscious that the court is familiar with the factual background. It's recited in my skeleton at paragraphs 9 to 24, but I don't intend at this stage to take up anything further. I think the only point that I need to make, it can be made by reference to the application notice and points of claim if necessary, but I think it's common ground. There was something substantive being determined at this application. As Mr. Warman indicated in submissions earlier, one question was whether or not certain transactions were sham transactions. That is a substantial factual question that was going to be determined. So the question then is going on to the first key question in my submission, was the matter a trial? The question is whether the hearing to determine that question, amongst others, was a trial or whether it was some other lesser hearing than that, as Mr. Warren mentioned earlier. Now, I addressed the question of whether or not something is a trial in sections B and C of my skeleton. The court's read that. It's common ground that there is not a relevant definition in the CPR for our purposes. So in my submission, the court must understand trial according to its natural language. We do have two authorities which do touch on this. I will take you to both of them because in my submission, force lux is relevant despite the judge considering it less so below. They are the only two occasions that Mr. Warman or I have put before the court as being an occasion where there was some relevant consideration of this. If I can turn the court's attention first to force lux, it's in the authorities at tab 6. Page 148, it's a decision of the Court of Appeal. The lead judgment was given by Mr. Justice Warren, and it was in the context of possession proceedings by a landlord, and in particular, a tenant didn't attend the hearing, and a question then later arose whether they were entitled to set aside an order made of that hearing under CPR 39.3. We can pick the judgment up at, briefly at page 153 of the bundle, where at paragraph 22 the judge is just reciting certain rules applicable to possession claims, here 55.8, and I just draw the court's attention to subparagraph 1. At a hearing, the first hearing of a possession claim, the court may decide a claim or give case management directions. And the judgment is then dealing with precisely the question of what is the nature of that hearing. And we see that over the page 155 at paragraphs 32 and following. Mr. Justice Warren explains that the judge hearing that possession claim for the first time is given two options. He may decide the claim or he may give case management directions. At paragraph 33, the judge explains that if the claim is decided, it is going to be on the basis of the evidence before him. there's a discussion of an exceptional case where essentially the judge says, I've got a short possession claim, but I'm going to elevate this now to the trial. But at 34, the judge says that's a pretty exceptional case. What's more normal is essentially you have a summary determination on the basis that there's nothing on the paper to suggest any material dispute. And we see that picked up in the final sentence of paragraph 35. And then, this is important, the first sentence of paragraph 36. I do not consider that such a process of determination and decision can sensibly be called a trial as a matter of the ordinary use of the word. And then on the third line, he describes it as a summary procedure. And then at paragraph 38 draws a distinction between a process of determination and decision, which is firmly on the side of a summary disposal, as opposed to a full investigation of trial, which is on the other side of the line. In my submission, there are 2 points to be taken from this. The judge is describing essentially 3 different forms of hearing. The first form might result purely in procedural decisions, such as a case management conference. The second type of hearing might result in a summary determination of the issue. And in that case, the court is not engaged in a full investigation. It is deciding that one party's case or the other has no real prospect of succeeding and doesn't need to be fully tried out. And then the third type of hearing that the judge is explaining is one where there is a full investigation, and that is the trial. The second proposition I take from this authority is that a hearing can only commence as a trial if it is expected to result in the full as opposed to a summary determination. And we see that in Mr. Justice Warren's explanation that there could be this exceptional case where what might be a summary disposal or a case management hearing turns into a trial. But in that case, it is turning into a trial because the parties don't know beforehand whether or not there is going to be that full investigation. This helps me go some way to answering the question that Lord Justice Arnold posed to my learned friend earlier, which is how do you determine whether or not a hearing is a trial or not? Because you can have trials and lesser types of hearings which might determine a point. And the litmus test in my submission is whether there is a reasonable expectation on the part of the parties in advance that there is going to be a determination of a point following a full investigation. That's as opposed to a summary investigation. Considering how that maps onto the procedure that we had in this case, when the underlying application by Decolace was first issued, it was listed for Mr. Ashworth, King's Counsel, for 2 hours. And at that stage, that hearing could not have been a trial, because in advance of that hearing, no party could have known whether or not it was going to result in that full investigation and a final determination. It might have resulted in a summary disposable, or it might have resulted, as it did, in case management directions. But for those reasons, it's not a trial. But in my submission, Mr. Ashworth then gave directions for the subsequent hearing, and we'll come to those directions in a minute. And the effect of doing that was to set up the next hearing as a trial. That's because any reasonable expectation following those directions was that the next hearing was going to involve a full investigation of the facts, a determination by the judge, and I would submit that determination would be a matter that would form res judicata.
Is that a convenient moment?
That is a convenient moment, yes.
Very well, thank you very much. 2 o'clock, please.
So rise the table.